This is The Probe. Tonight, we delve into one of the most pressing issues in Ghana's political landscape right now, the controversy surrounding the Speaker of Parliament, Alban Bagbing's communication to Parliament last week about 4 parliamentary seats, Aguna West, Suhum, Amenfi Central and Fomena, being declared vacant, and the impact on our democratic processes. As we speak, both the NPP and the NDC caucuses are claiming to be the majority in Parliament, even though Ghana's Apex Court ruled on Friday that Parliament recognizes and allows the 4 MPs to represent their constituencies and carry out the official duties fully. Well, we know that the application was filed ex parte by Alexander Afenyo-Marking, meaning that neither the Speaker, Alban Bagbing, nor Parliament was joined to the case, which was heard by a panel of Supreme Court justices presided by Chief Justice Gertrude Tokonu herself. How then do we navigate these challenges without compromising the integrity of our Parliament and plunging the system into chaos? So we know the situation so far. Just let me walk you through it briefly. So as it stands today, the Supreme Court has issued a stay of execution on the Speaker's ruling, which declared 4 seats in Parliament vacant. We've heard the NDC caucus in Parliament mention that they are yet to be officially served, so they are unaware about this. So for them, the status quo remains in terms of the Speaker's ruling. So that is what we've seen, at least the directive to remain in effect until Supreme Court delivers its final ruling on the substantive case that we know about, which we are following up on. The Speaker, we know, declared these 4 seats in Parliament vacant, for which reason we have this controversy. After a debate, he gave some 2 days notice and then delivered that ruling. It's not a ruling, they say, it's a communication, at least in the Speaker's word. He gave a communication to Parliament, and that communication has become a subject of controversy. So these are the 4 accomplices, 3 on one side, the NPP side, and 1 on the minority side, Kwache Aka, the Amenfi Central MP for the NDC, and on the majority side, which is the NPP, Kwejua Sante for Suhum, Cynthia Morrison for Aguna West, and then Amwakwesi Ama, the second Deputy Speaker of Parliament for Fomena. At least he's been a subject of controversy before. He's no stranger to this particular issue that we talk about. So as it stands now in Ghana's Parliament, what we knew before this particular ruling or communication by the Speaker, we had the NPP side forming the majority, including the Fomena MP having 138, with the NDC side having 137. So with the new communication that we have, it makes them 136, which makes them the majority, and 135 for the NPP, which makes them the minority. But this has been questioned, and it is still the subject of controversy that we talk about. And this particular petition, we know, was put forward by the minority, and we had Harun Idrisu on a campaign platform last weekend, a hint about this particular action. Some have questioned whether it should have been a motion instead of a statement that was put before the Speaker, for which reason he gave that particular communication to the House about declaring these 4 seats vacant. That's the situation as we see it. So these are the 3 and the 1, at least. We've gone through all that, we understand. But what does the Constitution say? And this is the particular article that we've heard over the period. I'm sure you don't need to be a law student by now to have heard about Article 97 G and H. It's been quoted all through, thrown about when it comes to this particular issue. A member of Parliament shall vacate his seat in Parliament. G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member, or then we bring in the H, which says if he was elected a member of Parliament as an independent candidate and joins a political party. Then we know what happened in 2020. That's where most people cite as the precedent, which says in 2020, MP for Fomena, who then was an MPP MP, had a seat declared vacant after he contested as an independent candidate. But the argument there is that there was a formal communication by his party, the NPP, with the General Secretary back then, John Boedu, which was communicated to the Speaker. And that's the argument that has been advanced by the former Speaker of Parliament, Professor Michael Quay. In that interview, he granted us that he sticks by his decision that was taken, even though now many have criticized that particular decision. Why they did not do that back then, they are doing now, insisting that that decision he took back then was wrong, was not a good decision, for which reason it should be cited for this particular decision to be taken by Alban Bagbing as well. He mentioned back then that he has pronounced himself publicly as an independent and has filed his papers to compete against the party in its official capacity as an independent on the 7th of December 2020. And that's Professor Michael Quay back then, and goes on to say, having forfeited the membership of the party on whose ticket he was elected to Parliament, the operative language of the Constitution is that he shall, which is mandatory, vacate his seat in Parliament. He's been defending that particular decision he took back then in 2020. What then happens going forward on Tuesday? We had the majority hold a press conference, the NDC caucus, I should say, hold a press conference today in Parliament, insisting that they are the majority side. They do not know, they have not been officially communicated just yet too about the Supreme Court's ruling last Friday. These and more are the issues we're going to unpack today or tonight right here on The Probe. And of course, here on The Probe, your views are always welcome. It's an audience-based, program. So we welcome every view right here with the hashtag The Probe on all our social media platforms. We are live on the Joy News channel, on Joy 99.7 FM, myjoyonline.com, and all our social media platforms. Please do stay with me. Tonight, my guest in the studio is the Boku Central MP, Mahama Ayariga. You're welcome to The Probe, sir.
Thank you.
Well, there's a lot to unpack tonight. So we'll start off with that press conference that was held today by the NDC side. And he's been speaking to some questions also that was raised. Parliamentary Affairs correspondent Kwekwa Sante gives us a wrap of the issues. Later on also, we'll be joined by some political analysts, scientists as well, via Zoom. Dr. Kwame Asante will join us. We'll take their views briefly. And then Professor Smart Sapong is also a political science scientist with the Kumasi Technical University. Also join us briefly with your thoughts and comments. You want to stay? I am Emefa Apau, and this is The Probe. You're welcome.
On Thursday, Speaker of Parliament Alban Bagbing delivered a ruling, or what some have said was a declaration, that effectively made the NDC group in Parliament the majority caucus in the House. But 24 hours after that, the Supreme Court ruled to stay the execution of that ruling by the Speaker of Parliament. The NDC MPs, however, say that the Speaker of Parliament did no wrong and they will resist any plan to push them back into the minority.
For the avoidance of doubt, the Speaker's decisions to declare the 4th seat vacant is lawful exercise of his responsibilities derived from the 1992 Constitution and the Standing Orders of Parliament. The effect of the Speaker's declaration is that currently, we no longer have an independent member of Parliament. The MPP has 135 members of Parliament only. The NDC has 136 members of Parliament, and there is no second Deputy Speaker of Parliament. We will jealously protect our new majority status and will not bow, retreat, nor surrender our lawfully earned status.
Dr. Kassia Latufosin, who is the NDC leader in Parliament, has been announcing the plans that the NDC group have if they stay in the majority, including to repeal the e-levy and the betting tax.
It is indeed true that we will use our new majority numbers to benefit Ghanaians by introducing private members' bill to remove the e-levy and to reduce the suffering of the people of Ghana. Yes. It is also true that we will use our new majority to remove the betting tax and other nuisance taxes. Yes. We stand with him, pledge our support, and urge him to protect the dignity and sanctity of the Parliament of Ghana. In the same vein, we call on Ghanaians to stand by the Speaker and resist oppressors' rule. From day one, we have not reneged on our fight for the people of Ghana.
When asked specifically about this Supreme Court ruling, Mahama Ayariga, the NDC MP for Boku Central, says until and unless the Speaker of Parliament comes to the floor and informs them that that is the new course of action, they will still consider themselves as the majority.
We are not aware of any law or any constitutional provision that enables anybody to suspend a decision of the Speaker in Parliament properly constituted. Be that as it may, we as parliamentarians act on the basis of communication coming to us from the Speaker. We don't hear things in the news and act on them, or cite copies of records of proceedings in any court on social media and act on them. We act on the basis of communication coming to us from the Right Honorable Speaker. And if that communication says we should walk into the sea, we walk into the sea, because we listen only to the Speaker and nobody else in relation to the integrity, the legality, and the appropriateness of what has happened in the chamber of Parliament.
On Tuesday, the House is set to resume after it adjourned last Thursday, and it's going to be a showdown because both sides are now carrying themselves as the majority in Parliament. But of course, the majority can't only be one side, and it is only one side that can sit on the right-hand side of the Speaker. But with both the NDC and the NPP pushing themselves onto that right side, it is left to be seen what exactly is going to happen then, with even claims now from the NDC MPs that certain soldiers are set to be deployed to the precincts of Parliament on Tuesday when the House resumes. Reporting for Joy News, Kweku Asante, Parliament House, Accra.
Many thanks for staying with us here on The Probe on the Joy News channel, on Joy 99.7 FM. Of course, my colleague, Kweku Asante, Parliamentary Affairs correspondent, giving us a wrap of what transpired in Parliament today by way of that press conference that was held by the NDC caucus in Parliament, led by the leader, Ato Forcing. Well, let's start off, at least I've introduced my guest in the studios to you, Mr. Mahama Yariga, Boku Central MP, joining us, and we're going to unpack all the issues by way of what the NDC side is talking about in terms of what they want us to actually know and understand, why they insist that they are still the majority, even though we've had that ruling from the Apex Court. But let me first start via Zoom with lawyer Sam Okujeto. He's a member of the Council of State, also joining us via Zoom briefly. Let's engage him on this particular issue when it comes to matters of law. We're grateful for your time here on The Probe on the Joy News channel. Indeed. Thanks for joining us. Good evening. You'd have to unmute, please. Lawyer Sam Okujeto, please, you would have to unmute again. My producers tell me.
Right.
Great.
Okay, can you hear me now?
Loud and clear. I would first want to find out where you stand on the side of the law when it comes to this particular controversy surrounding the declaration of vacant seats by the Speaker. I ask that because at least in the last few minutes you've been hearing from Mr. Yariga saying they are not aware of any constitutional provision that seeks to suspend a decision of the Speaker. So first, let me know where you stand on the side of the law when it comes to this particular controversy.
Well, it just has to be clear to all of us that Parliament makes the law, but Parliament does not interpret the law. And the Constitution is the supreme law of the land. It was not Parliament that made the Constitution. It's the people of Ghana. If you read the preamble, it's quite clear. And the power to interpret the Constitution is given to the Supreme Court and not to Parliament. Mm-hmm. And therefore, there's a controversy as to whether any particular power can be exercised or not exercised. It is the responsibility of the Supreme Court and not of Parliament. It's rather surprising that my legal colleagues in Parliament don't want to apply their mind to legality, but rather trying to use sentiments to interpret the law. And I don't think it's in our own interest, because the kind of confusion which is being created now, I do not know where it's going to lead this nation. There is a president who is elected. He serves in office until 7th January, where somebody else is sworn in. Beyond that, there is no other person who can be a government of this country. And Parliament is not a government. Parliament only makes rules and makes laws. And so I am just cautioning my colleagues and all Ghanaians for that matter. Let's put sentiments aside. There comes a time when cool heads are required for us to resolve controversy or issues that we disagree with. Sometimes some even suggest that we can even disagree agreeably and not to take it as if we are fighting one another all the time. The Supreme Court has made a ruling. Someone said they don't know. Well, today is Sunday. Monday is also a working day, even though Parliament does not sit. Orders of the court can be served. And so let's just take a cool head and stop what we are doing now, because I don't think it's the interest. I heard utterances by even lawyers on the air as if they are trying to organize that there should be a coup d'etat. Maybe they are too young to know what happened over 30 years ago when soldiers seized power. Indeed, 3 judges were abducted and killed because they felt that those judges had given judgments which they did not agree with. The Matters Day that the lawyers celebrate yearly over the last 30 years is a warning to all of us to say that no situation is permanent. You hold political office only for a period. Tomorrow you may not be there. Another group will be there. So let's just keep a cool head. The Speaker has made a ruling. Whether indeed he himself has the power to declare a seat in Parliament vacant is another issue, because the same Constitution also says that to declare a seat vacant is the responsibility of the High Court. And I don't remember anybody taking any issue to the High Court for a declaration to that effect.
Now that you've mentioned the issue about the High Court, Mr. Okudzeto, that's where some lawyers, at least, we've heard them say that that's where the Supreme Court erred, because you've mentioned that this matter should have been the High Court that's deciding on it. Some have said it is necessarily a matter of human rights, and it is a case where the Supreme Court should not be doubling in. It ought to have been the High Court dealing with this matter as against the Supreme Court dealing with matters of constitutionality. Do you agree that the Supreme Court erred when it comes to this?
The same Constitution gives power to the Supreme Court to decide any matter. It is also in the Constitution. So I don't know which part of the Constitution they are reading. You see, you don't take a clause in the Constitution and stop there. Read it, read the whole context, and then you begin to appreciate why it was so. The Supreme Court has power to decide on any issue. On any issue.
So for you,
where it is not, where the High Court is not authorized, the Supreme Court can still do it. Where the High Court is authorized, the Supreme Court can still deal with such matters if the matter come before them.
So for you, this issue is not a matter of human rights or constitutionality, that's such that the Supreme Court should be the one dealing with this. For you, the Supreme Court did not err at all in this particular matter, in deciding on this.
Yeah, because when they are talking about human right, what is actually human right? Do they understand the full gambit of that? What you are doing affects the president. It affects his party. It affects the whole governance process. How do you just limit it and say it's a question of human rights and therefore you cannot go to the Supreme Court, you must go to only High Court? In any case, if it is so, since the question was to determine a person whether he can be a member of Parliament or not, it's a matter for the Supreme Court. Did they go to the High Court to go and challenge those people, their membership of the House? They did not.
It was a statement on the floor.
To sit as a judge and then made a ruling.
But this matter was brought
and
before
when
him.
Challenged, now they are saying it is not a ruling, it's only a declaration.
It was brought before him. It was brought before him.
One and the other?
I was asking that it was brought before him by a side of the House. What was the Speaker supposed to do?
It is his House. It is his side of the House. That brought the issue.
He's a Speaker. He doesn't have a side, does he? Does he have a side in the House?
Well, he should not have a side. That's why his behavior rather is showing as if he is supporting a side. It is that his behavior which some of us who have also been involved in politics before see that it is he should not behave like that.
But you mentioned that everybody is dealing with this issue with sentiments instead of legality. I think you're falling on your own sword.
That's exactly what I say. I am saying that if it's an issue as to whether they are talking about human rights, who is supposed to take the matter to the court? Who? Is it the members who are allegedly declared to no longer be members of parliament? Are they the ones supposed to go to the court? Or is it the members who brought this matter to parliament for asking the speaker to make a ruling? Why did they not go to the court to go and challenge those persons' membership?
Where do you stand on this argument about Speaker Michael Quay, former Speaker Michael Quay, erring on that decision that people have now referred to as the precedent for why we are here today? Did he err back then?
If you listen to the parliament, the debate that went on in parliament, the speaker put that matter aside. He didn't say he was following Michael Quay's ruling. In any case, in the case of Michael Quay, it was the person's own political party that wrote to parliament to say that he was no longer a member of the party. In this particular instance, it was not. There was no communication from any political party connected with those people at all. It was the people at NDC people who raised the matter in the House. And then the speaker then should have referred the matter to the court. But he purported to sit as a judge and made a ruling. And this is what they have gone to the Supreme Court to challenge. That's why I'm saying that let's get our cool head on the matter.
Yeah, it's the cool head that we are looking for. Going into Tuesday, we have the NDC side and the NPP side both claiming to be the majority until they are served, duly served like they are waiting for. What should happen? At least you're a member of the Council of State. I'm sure you are concerned about this particular matter degenerating and the chaos that people would not want to see like we've seen previously in Parliament. What will happen as a Council of State member at the Council of State level? I'm sure you are all concerned. What exactly are you advising? What is happening at your level?
Of course we are concerned, but don't forget that we don't jump into a phrase. Normally, we would have been there to make reference what the matter is referred to us, and we can advise Parliament if they refer the matter to us. Or the President can refer the matter to us and we'll deal with it. Or anybody else can actually refer that matter to us and we deal. We don't jump into a fray. That's not the job of the Council of State. Okay. Of course, we have the power to call all of them to a meeting and to advise. And I'm using the word advisedly. We advise. We have no compulsion power like the court has, where we can say, do this or don't do that. No, the Constitution says that we can advise, but they are not bound to take our advice. But as a citizen of Ghana, and also holding that important position as a member of the Council of State, I'm worried about the way things are going. And so I'm using your platform now just to make an appeal to the Ghanaians, particularly our MPs and the Speaker, to say that we need a cool head. We don't want to draw this country into chaos. The whole sub-region is in a mess, and we seem to be the only country which is seem to be governing ourselves properly. So let's keep it like that. Let's not ruin the reputation of this nation. I beg all of them.
We are grateful. That's a lawyer Sam Okujeto, a member of the Council of State, joining us with his views on all the controversy so far. We indeed are grateful. Let me come to the studio. Ms. Ayaga, thank you once again for your time. So you heard the various views, but I've heard the lawyers also say that the principle of law is clear, that whether a court decision is manifestly or patently wrong, no matter how lawful or unlawful or unconstitutional, it must first be obeyed, first and foremost, before triggering processes to set it aside. But what we've heard from members of your side, at least, is that this is not an order from the Supreme Court that you're going to obey, because first they say you have not been served, and then also the Supreme Court lacked jurisdiction on the matter, and they erred in that particular decision. What does the leadership say?
Well, I mean, for us, as we speak now, Our position is very simple, that we are unaware of any decision that suspends the communication of the Speaker that the 4 seats have become vacant, which results in the balance of power in Parliament being altered, where the NDC now becomes the majority caucus and the NPP becomes the minority caucus. The so-called suspension of the decision, like you have said, has not been communicated to the Speaker of Parliament.
Okay.
And the Speaker has not communicated to us. But we're saying that as we sit, we are the majority caucus in Parliament, and we will act as the majority caucus in Parliament. Because we strongly believe that the Supreme Court of Ghana has no jurisdiction to suspend a decision of Parliament. We respect the institution of the Supreme Court, and we expect the institution of the Supreme Court to respect the Constitution, which establishes it. And in this instance, we believe that there has been a woeful failure to respect the Constitution that establishes the court and gives it the powers that it is supposed to have to do the right things.
But the issue
Let's
of
just say-
jurisdiction has been raised, Mr. Ayariga.
Yes,
that
so the issue
Supreme
of
Court
jurisdiction.
is clothed with all powers to deal with every matter. How then do
That's
we say
not
that
true.
they do not
It's
have
not true.
jurisdiction
It's
in
not
this?
true that the Supreme
Okay.
Court is clothed with the power to deal with every matter.
Okay.
The Constitution is very clear, and I'm surprised that my respected senior Uncle Sam doesn't appear to have read Article 99 of the Constitution quite closely, the way that I expect him to do. Because I'm holding the Constitution here, and it's written in English, and I expect the viewers to just listen to what it says and then form their own opinion whether the Supreme Court has jurisdiction to entertain the matter that came before them. It says in Article 99(1) that the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member has become vacant. Now, you see, before you ask, listen carefully. Listen carefully.
Not deal with the issue about the vacancy.
Listen carefully. Listen carefully.
Okay.
The Constitution has a structure.
Okay.
Before Article 99 is 98, which deals with emoluments of members. But before 98 is 97, which is the article that is the subject of all these discussions. So you see, the Constitution is structured in a certain way. 99 discusses tenure of office of members and says a member shall vacate his seat in Parliament. He, the member, shall vacate his seat in Parliament. So you yourself are to vacate your seat in Parliament. It doesn't say that a court shall declare a seat of a member having been vacated. It says that a member of Parliament shall vacate his seat in Parliament. So you, the member of Parliament, when you do any of the things in 97(1), A, B, C, D, E, F, G, H, if you do any of these things, you are to vacate your seat.
So it's the view that you don't need the party to communicate through the Speaker or anybody.
I heard him say that. I heard him say that. Oh, the Speaker communicated without going to the High Court.
Nobody went to the High Court.
Exactly. He said the Speaker did not go to the High Court to enforce it. And I'm saying that the Constitution doesn't say anybody should go to the High Court. The Constitution says that the MP himself he should on his own vacate the seat.
But you
It's
all
English.
watched, they were with you in
Listen,
Parliament.
look.
You all watched, and that did not happen.
Listen.
As soon as they filed.
Listen, it is written in English.
Okay.
A member of Parliament shall vacate his seat in Parliament. So you, when you occasion these facts, you are supposed to vacate your seat. Okay?
Okay.
And then, if there is a dispute in relation to whether or not the facts that occasion the necessity for you to vacate your seat, if there's a dispute about those facts, or whether or not those facts apply to you, then the succeeding clause, which is 99, which comes after 97, now says that the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member has become vacant. So you are to, on your own, vacate the seat. If you don't vacate your seat, is that okay? And then there is a dispute about it, then you can go to court. And the court that you should go to is the High Court, not the Supreme Court.
So where does
Are you getting the
go?
situation?
Let me just.
So Afenyomakin and his colleagues who rushed to court, I mean, I keep saying I am scandalized because anybody with a structural understanding of our Constitution will know that if any matter relates to Article 97, it is Article 99, which comes almost immediately after it, which guides you as to how to deal with that matter, which is that you should go to the High Court. So you get up and run to the Supreme Court. You are going to the Supreme Court on a question of interpretation of the Constitution. The same Constitution says, no, don't go to the Supreme Court. Go to the High Court.
But interpretation of the Constitution,
yes,
where does that power lie? Is that not the Supreme Court? Any matter of constitutional interpretation, where do you go?
The Constitution itself creates the courts. It has created the High Court.
Yes.
And then it has created the Supreme Court. It has assigned certain tasks and responsibilities to the High Court,
yes,
and then assigned others to the Supreme Court.
Yes.
So again, there's an issue of structure here. So go to Article 130 of the Constitution and then see the structure that it intends to impose on us. Listen carefully. Article 130, which talks about the original jurisdiction of the Supreme Court.
Of course.
Okay? Says that 131, subject to the jurisdiction of the High Court. Subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation of this Constitution.
So you consider that as a human rights issue, but some have said it's also a constitutional issue and not just a human rights issue, for which reason you are activating the original jurisdiction.
Everything in this Constitution is a constitutional matter.
Okay.
Everything is a constitutional matter because it is in this Constitution. And I'm saying that even though everything in this Constitution is a constitutional matter, the same Constitution has created two pathways
together
to enforce these same provisions of the Constitution, and says that there are matters that I reserve to the High Court to deal with.
But does that mean that
and then there are other matters that I reserve to the Supreme Court to deal with? And I'm saying that where the language of the Constitution expressly says that as for this matter, I reserve it to the High Court. And you wake up and you go and bypass the High Court and you run to the Supreme Court for reasons best known to yourselves. And then you come with that kind of hudious ruling and say we should abide by it. We will tell you that we know the Constitution. And we are saying that we in Parliament know the Constitution. We work with the same Constitution. We are saying that the Constitution does not give the Supreme Court any mandate to determine whether a seat is vacant or not. That is the issue before us, whether or not a seat is vacant or not. That is the issue.
Because the majority, you stay the decision that was taken by the Speaker of Parliament was to hear the substantive case. Is that not correct?
We're saying that it has no mandate to hear the substantive case. That's our point.
Okay.
That the Supreme Court has no mandate to hear the substantive case because Article 99 is clear. Article 99 comes just after 97.
Okay.
And 97 is what is in issue. And it talks about the vacancy of a seat. And 99 says that when there's an issue about whether or not a seat is vacant, go to the High Court.
Okay. So for you...
Why didn't they go to the High Court?
Okay. So then before we started, Mr. Ayariga, you remember that I mentioned that if a court gives a wrong ruling, the first thing you do is to obey, no? Before you then trigger the processes to correct it. But what I hear you say is that that does not stand. Once it is wrong, you are not going to obey. Is that what you're saying?
I'm saying that so long as we, the minority, are concerned. In fact, the directive is not directed at us.
Okay.
The directive is to the Speaker.
A ruling that you are going by.
The Speaker of
a ruling
Parliament.
that you are going by.
The Speaker did not make a ruling. That's
a communication.
So even the judges are confused about the facts in the House. See, the Speaker did not make a ruling. The Speaker acted on the basis of his attention being drawn to the existence of one of the circumstances in Article 97, which circumstance, if it does occur, should lead to a member himself vacating. So if we see the member not vacating, it is our job to make a statement drawing the attention of the Speaker to the occurrence of one of the circumstances in 97. That was, Mr. Speaker, you don't know, but that man sitting there, he has gone to file as an independent candidate, even though he's a member of the NPP. And Mr. Speaker, according to 97 1G or H, he is supposed to vacate his seat himself. He's supposed to get up and walk out of this parliament. But he's still sitting there. Is that okay?
Okay.
Now, Mr. Speaker is supposed to confirm the fact. Okay? But then when the fact is public, Mr. Speaker can just take notice of the fact that the matter is public because we also had copies of the notice of polls. The Speaker would have actually investigated if we didn't have evidence. But in his response, he says there is a notice of poll, and the notice of poll shows that, in fact, they have filed as independents or they have filed on the ticket of political parties and etc. So the notice of poll serves as evidence of the fact that one of the circumstances provided for in 97 has occurred. And so the person on his own should walk out, because that's what the Constitution says, that you as a member of Parliament should walk out of Parliament yourself. It doesn't say somebody should go to court and get a court order to come and compel you to walk out. You should walk out. If you don't walk out, the Speaker is supposed to, under Order 18 of our standing orders, which standing orders are provided for by the Constitution, which says in Article 110 that subject to the provisions of this Constitution, Parliament may, by standing orders, regulate its own procedure. So, what is the procedure for telling a member that he is no longer part of this House because one of the conducts prohibited by Article 97 has occurred? It is Order 18. It says, the Speaker shall inform the House of the occurrence of a vacancy of the seat of a member under Clause 1B to E, G, and H of Article 97 of the Constitution. You see, now 18 now gives us clear guidance as to how to proceed, which is that if any of the facts that 97.1 prohibit from occurring do occur, then under Order 18, the Speaker shall inform the House. Shall. It is mandatory. Not that he may. No, he shall. Once the facts occur. So the Speaker shall inform the House of the occurrence of a vacancy of the seat of a member under Clause 1B to E and G and H of Article 97 of the Constitution.
So it's your position that you don't even need a formal communication from the party?
We made a statement to draw the attention of the Speaker to the occurrence of the facts. The political party may also have written, as in the case of Mike Okwe, where the party took an interest in the matter and wrote to draw the attention of the Speaker.
It should not necessarily come from the party.
And we are even saying that if we had not even drawn the attention of the Speaker, and the Speaker had become aware of the facts, it is the duty of the Speaker to enforce this Constitution. So he on his own should have communicated to us that, look, I have become aware that you have gone to file as an independent, or you have gone to file on the ticket of MPP, and therefore you are no longer eligible to...
Without a hearing. Without a hearing.
But you see, that is the other problem that people are raising. Please, I have read 97.
Exactly.
Has 97 made provision for a hearing?
It says it shall.
It says shall. It says once the circumstances occur, you yourself says a member of parliament shall vacate his seat in parliament. You should vacate your seat if you engage in any of these conduct. Now, when somebody says you have engaged in any of them, and you say, no, I have not, then we will wait to hear you. Because you say, no, I have not. I have not tried to leave my party to join another party. Is that okay? I have not, for instance, let's say that CPP is in parliament represented by 2 MPs. Let's say PNC is in parliament represented by 3 parties. Then we go to file nominations. Then we see that the CPP candidate has gone to file on the ticket of the New Patriotic Party. Okay?
Yeah.
Then we draw the attention of the Speaker that, look, Mr. A has gone to file on the ticket of independent or NPP, even though he is CPP. So he has automatically vacated his seat on the basis of Article 97. They said, no, please, Speaker, hold on. There is an alliance between CPP and NPP, and based on that alliance, there's an agreement that those of us who are here on the ticket of CPP should now file on the ticket of NPP. Okay? So I didn't go to do it on my own, but my political party agreed with NPP, and that is why I'm complying with a directive of my political party. Article 97, Clause 2 protects that MP. Because 97, Clause 2 says that, notwithstanding paragraph G of Clause 1 of this article, a merger of parties at the national level sanctioned by the party's constitution or membership of a coalition government of which his original party forms part shall not affect the status of any member of parliament.
Okay.
Are you getting the situation? So there are circumstances that could permit a member to go and join another party or to go and file on the ticket of another party if there is a coalition agreement by the parties and etc. That becomes a defense. So if you challenge and say, no, I haven't done it, we are obliged to hear you. Okay? But none of the MPs complained. How can you be crying more than the bereaved? They know what they have done. They were entitled to be in the House. When we raised the issue, they had 2 clear days because Speaker said, give me 2 days to ponder over the matter. Those 2 days, they could have gone to Speaker and said, Mr. Speaker, no, what they are alleging they have done, I haven't done. Because this was a matter of public knowledge that this matter has been raised. One of them knows. Esiama, it happened to him in 2000. He was sacked from Parliament. He didn't attend Parliament. He went and contested and came back and even got rewarded, when there was... of course, when our seats were equal, MPP, NDC, and then they now went looking for him, they gave him Deputy Speaker, as consideration for him to join them and do business with them. So the whole question of not being heard doesn't arise because none of them is challenging it, none of them is complaining. Afenyomakin is only fighting because he has lost his post as a majority leader, and so he's running everywhere and then cajoling, Supreme Court judges to do the unheard of things that is embarrassing the Supreme Court.
Well, Mr. Ayariga, I'll take you back to the issue about that Supreme Court ruling.
Yes.
I've heard you extensively mention, and others also mention, that the Supreme Court erred. Others also disagreed. But if your intention is not to create chaos on Tuesday in Parliament with your insistence that you are indeed the majority in spite of that particular ruling, even though you've said that until the Speaker communicates to you and say you should jump, you only ask how high you should jump. Why then are we not waiting for that rather than insisting that come Tuesday, you are the majority and nothing will stop, even going ahead with some of the policies that you're hoping to correct?
Well,
is that not a chaotic move your side is making?
Well, disagreeing with a bad, unfounded communication from the Supreme Court, I don't see that. I don't see that.
It's a ruling. Unlike the Speaker's own, which was a communication.
It's not a ruling. People are.
The Supreme Court asking Parliament to stay.
It's a directive.
A decision. Okay, a directive.
It's not a ruling.
But you said it's a communication.
It's a directive. A communication coming from the Supreme Court to the Speaker to stay his action. Are you getting the situation? So that is a matter between the Supreme Court and the Speaker.
How can you say this is a matter between the Supreme Court and the Speaker?
Have you looked at what the Supreme Court has said?
Mr. Ayariga, the same communication from the Speaker that you are acting on to say you are the majority. Now there's a directive from the Supreme Court to the Speaker, and you are saying it's a matter between the Supreme Court and the Speaker. How can you say that?
Because those are the facts. The facts are that on Friday, the Supreme Court is said to have met and then said to have taken certain decisions, one of which is to say that they are suspending a decision of
the Speaker
in Parliament, properly constituted. That decision has not yet been communicated to the Speaker.
Yes.
If it is communicated
to the Speaker, by the judiciary and the Speaker agreement, it's supposed to be served on Monday.
If it is communicated to the Speaker, it is for the Speaker to say he accepts or he doesn't accept. And we are saying that as we sit here.
It's for the Speaker to say he accepts the Supreme Court's directive or not?
Yes, it's for him to say he accepts or he doesn't accept.
He's clothed with such powers.
And who says the Supreme Court is clothed with powers to intrude into the business of Parliament and suspend decisions of...
Even if it violates the Constitution, if the Speaker is set to make a decision.
Have they established that it violates the Constitution?
Exactly. So I'm asking you as a lawyer.
Have they established that it violates the Constitution?
But if we get to a point where the legislation is refusing to accept directives from the apex court of this land, where are we going? We are going back. You are restoring the law of nature in this country, where the strongest fights and wins. Is that where we want to get to as a country? You are the lawmakers. You should be setting the right example, is what people have said.
That is why you should have knowledgeable people in the Supreme Court. You should have people who know their law. Do you know why?
The Supreme Court is not made up of knowledgeable people. If
they were knowledgeable, they would have known that the U.S. Supreme Court, in the case of Baker and Carr in 1968, said that there are certain matters that are, by their nature, political matters within the domain of the legislature and the executive. Those matters, the Supreme Court should run away from them. They should not get entangled in those matters. Because when they get entangled in those matters, there will be this type of clash.
Even
where the legislature, listen carefully, where the legislature will say one thing and then the Supreme Court will say another. Where the executive will say one thing and the Supreme Court will say another. That is what happened in the Salah case. In the Salah case, where President Bouzier said no court can sit and direct him as to how he should run the affairs of this country. It's a similar circumstance. In Baker and Carr, the court enumerated a number of circumstances and showed that those circumstances are by their nature political, divisive. Is that okay? Controversial. They are matters that are within the domain of the legislature. the Supreme Court should run away from them. Don't get involved in those matters. Don't hear those matters. Leave the politicians to deal with their issues. This is a classic case of a situation where the legislature has done what clearly the language of the Constitution authorizes it to do. The Supreme Court, you hurriedly meet without giving the legislature hearing. You are talking about hearing. Did you give the legislature hearing?
It was an ex-party motion.
Did you?
It was an ex-party motion.
So that is the more reason why they should know that in controversial matters like this, let me hear the other side. In politically charged matters like this, let me tread cautiously. And so they shouldn't have, with the kind of haste, somebody files an application in the morning and by afternoon you're already meeting. When the chief imams, the pastors have been demonstrating and petitioning for the past 2 years that you should quickly sit on the issue of LGBTQ and then give them a decision, and you have been sleeping and snoring on your benches and not paying attention to them. All of a sudden, somebody comes in the morning and by afternoon you are able to sit and give directives to the legislature. The point I'm making is that this is a classic case of what the Supreme Court of America, where we are learning our jurisprudence of Supreme Court from, said, Supreme Court, don't get involved in these matters. How can a Supreme Court be telling us that, oh, I have to injunct Parliament, I have to restrain them because one side has come to say that, oh, if you allow this situation to prevail, the business of government will be stopped. Is that your business? I have said this on other networks that it's not the business of the Supreme Court if the NDC in Parliament says that they are going to repeal e-levy. If the rules of the House and the processes in the House enable them to repeal, go and fight them in the House.
But the Supreme Court is not saying you should not repeal e-levy.
That is what they have.
That's not what the Supreme Court is asking at. But really, have you
read what they have said?
As a lawyer and also a legislator, I understand you. But
exactly.
let's get into the issues that most people have been raising concerns about. I would want to find out the legal implications of this position that at least we've heard your side, and also you being a lawyer. There are concerns that have been raised about the precedent that it was set and how rulings in the future will be treated because you're a lawmaker. And when we hear comments like that coming from your side, they are concerned. What do you say
we are building
about the precedent that will be set in terms of treatment of rulings in the future?
We are building institutions.
How do you build institutions?
Listen carefully.
When you do
we are
not
building
obey
institutions.
them?
The institutions themselves will not be perfect now. It is contestations like this or like these that will help the institutions to know what steps not to take next time. Baker and Carr didn't occur, in a vacuum.
Okay.
The United States experienced similar contestations between the legislature and the executive. And so they then developed the jurisprudence of the political question doctrine and said, look, there are certain matters that are political in nature. There are certain matters that are assigned to coordinate branches of government. We must respect those coordinate branches of government and avoid embarrassing them as a Supreme Court.
Are you
getting the situation? So I'm saying that it is based on that learning that they also developed this jurisprudence. And I thought that our judges who should know the Constitution and constitutional law, because they are supposed to be interpreting the Constitution, would have known this and acted properly in this instance. But I'm saying that it is the stance that we are taking that will teach the Supreme Court that next time don't do what
But there is a provision in law for you to chart the course of law when the case arises that you disagree.
Show me which law.
There's no law that says that when they are inherently, when they are wrong. So when the Supreme Court is wrong, why do we then go for reviews? Why do we go for reviews of the Supreme Court's decision? I'm asking, why is there room for appeal of decisions that are taken by these courts?
I'm saying that when the Supreme Court leaves law and jumps into partisan politics, it will soil its hands.
You will not review the
I'm saying
cases.
that,
You will not
I'm saying that when the
you will not
Supreme Court,
use the law.
I'm saying that when the Supreme Court leaves the law, and I've shown you the laws that are so clear.
Exactly.
And they have left the laws.
But I'm asking.
Listen carefully.
Okay, I'm listening.
That when the Supreme Court leaves the law, which is so clear, directing them what to do, they leave it. And then out of whatever it is that okay? Decide to do what they have no business doing. They will soil their hands. And I'm saying that on Tuesday, we will know what the direction of the country will be. As a majority in Parliament, the NDC, we maintain our majority status until Tuesday when we hear from the Speaker.
Okay.
Because the Supreme Court
accepts
the Supreme Court says they are speaking to.
Will you move with the Speaker?
Because we act within the confines of the Constitution.
Okay.
And the Constitution says the Speaker shall preside, and that the Speaker is responsible for enforcing our standing orders, enforcing discipline, and enforcing compliance with our rules and with the Constitution. If we go into the chamber, the Speaker says, well, I have received this. I think it is proper, and I'm therefore suspending the decision. We are now acting on the basis of the Speaker's suspension of the decision. We are law-abiding. We are law-abiding. The people who are not law-abiding are the ones who are giving us this directive, because the law is very clear that they have no jurisdiction in the matter. The law is very clear that don't get yourself involved in the political issues of the legislature and the executive. The law is very clear that even when somebody comes to you under Article 2 of the Constitution and request for a declaration, do the declaration. Don't go suspending decisions of Parliament, because you have no business suspending decisions of Parliament.
Okay.
The law is very clear in Article 122 that you have no business interfering in the affairs of Parliament, because that is treated as contempt. The law is very clear in Article 115 that there shall be freedom of speech, debate, and proceedings in Parliament, and that freedom shall not be impeached or questioned in any court.
I'll take a quick break on that.
Any proceedings of the Parliament should not be impeached or questioned in any court. The Constitution says this. In the light of all these laws in the Constitution that says, one, you have no mandate. If there's an issue about vacancy of a seat, it's a matter for the High Court. Don't interfere in the proceedings of Parliament. Don't sit and direct Parliament as.
But I'm not sure the book you're holding also says even though Parliament takes a decision that violates the Constitution, no court can look at it. Is that what you're saying, Mr. Ayariga?
I just said to you.
Okay.
That listen, I just said to you. No, please. It's important for me to make this point before you take a break.
Okay.
I just said to you that under Article 2 of the Constitution, you can go to the Supreme Court and ask for a declaration that the action violates the Constitution. But the Supreme Court should not stop Parliament from acting until it has made that declaration. That is the point I have made on every platform. That so far as I'm concerned, if the Supreme Court has said, we are suspending all our rules, we are going to hear the merits of your case, and we are going to rule on the constitutionality or otherwise of the action of the Speaker, and then they make a declaration that the conduct of the Speaker violates Article 97 of the Constitution, and therefore the action is null and void. And then pursuant to that declaration, under Article 2, subclause 2, they then give directives. I would have lived with that, because Article 2 gives them those powers. But I'm saying that somebody comes to ask for a declaration, you haven't done the declaration, and Parliament has done its work, and then you call and say, please hold on with your decision. That you are who?
Okay.
That you are who to say that we hold on with our decision?
Our radio audience will leave us at this point. They'll bring you a walk with Jesus, but we stay on, and then we'll wrap up this discussion right here on the Joy News channel, also on myjoyonline.com. I'll take some of your comments also that you've sent in via WhatsApp and also on our social media platforms. Let me take a quick break. When we return also, I'll bring in Professor Sapong to take his views also on this matter. This is The Probe. Please do stay with us. You're welcome back. You're still here on The Probe on the Joy News channel on Joy 99.7 FM, myjoyonline.com and all social media platforms. I'll do well to bring in some of your questions and your comments that you've sent in on all our social media platforms with the hashtag The Probe. Mr. Mahama Ayariga, the Boko Central MP, is my guest in the studio. You've also heard earlier Mr. Samuel Kujeto, lawyer Samuel Kujeto, joining us with his views. Let me bring in Professor Smart Sapong. He's a political scientist, also joining us briefly for his thoughts on what he's heard so far in terms of this particular controversy. We are grateful for your time here on The Probe. I'm told he's joined us via phone. We have some challenges with his Zoom connection. So let's talk about this controversy and what your side is in terms of what you've heard so far.
Great. A very good evening to yourself, and sorry I couldn't join via Zoom due to network challenges. Very good evening to the Honorable Ayariga in studio. My uncle Kujato spoke earlier. Good evening to everybody watching. I think this is a lesson to our democracy, and much as we are appealing to the side that did the press conference, I don't know whether I should call them majority or minority, much as we are pleading with that side to, let's get cool down and let's finish this section peacefully. We also have to avail ourselves to the lesson that comes with it. The legal side will be dealt with. I'm sure the courts will allow some time to hear them put final decisions so that it fits as a better or a better interpretation of the session in Vietnam. But what I think we should be doing is to look at what lessons we can have from a situation like this if it should happen again. And then perhaps prepare so that much as people decide to go independent, they should know the consequences thereon. It looks like the 4 members of parliament did not think through much what this meant for them. And they didn't know that the majority were just waiting for perhaps the Electoral Commission to print the polls notice, the notice of polls, so that that section of the law is activated. In fact, I will still continue to plead with that side because we just left it about a month or two for the session, for this parliament to go down. They can perhaps be a little moderate with their position, especially in respect of going against the Supreme Court's ruling and all those things. We don't have to go there yet. Let us, learn some lessons and then allow the Supreme Court to put finality to this when they come up with ruling over the substantive case. Then in subsequent parliament, members of parliament who decide to take the steps of these 4 will know the consequences thereon, and such is activated immediately it occurs. I think that should be the position now. It is too late a time, 3 weeks to election, 2 months to end of year, to raise this very serious situation in parliament. And I will just continue to plead that they allow cool health to reign.
Of this controversy, would you say is being driven by political interests?
Oh, everything that happens in Ghana has some political undertone, and we cannot run away from that. Politics is a good thing. Steps that we take to assume power or leadership, activities that we undertake to enable us assume leadership or governance. That is simply what politics means. And these are one of the activities they can do to make sure they reduce the number and then use the few weeks left to do some things that would maximize the chance of winning the upcoming election. It is allowed. Frankly, it is allowed. And we cannot rule that one out. All I'm pleading is that much as these activities in parliament can inure somehow to the benefit of the majority, they also are mindful of the fact that elections will be held at the polling station and they would need equal concentration in their various constituencies. That is not to say something is going on and they cannot speak to it. But what I'm saying is that, yes, politically it inures to their benefit, but there is the main contest down there waiting for them in their various constituencies. And they do very little of this national level politics. Find time, go to their constituencies, go and maximize their campaign so that the outcome will favor them. Politics, we cannot rule it out seriously.
But the concern also is about how this issue evolves going forward, to the extent that the NDC sides maintain they are the majority. We've heard the NPP also say that they are the majority. It leaves even the media, I'm sure I heard you also, confused as to how to describe the NDC and how to describe the NPP. How do you foresee this evolving, and how exactly are you hoping it will be dealt with? Because there are concerns even about the Supreme Court interfering in this matter or directing this matter, and the concerns that have been raised when it comes to the matters of law.
Well, so in the matter of the Supreme Court, I think my position will not differ from what the very
Oh dear, I seem to be losing Professor Sapong.
Yes.
Okay,
Can you hear me now?
Much better.
Good. So I was saying that respect of so-called interference, my position will not differ from the position of the very senior citizen Samuku Jato. My view is that if we respect them and call them Supreme Court, then we do not have to limit them as to what matters they take interest in, especially that has got to do with interpretation of some aspects of the Constitution. So I will not emphasize much. I side with the very senior Okujato on that matter. And it will be our responsibility as citizens to accord that court the respect that they deserve. In fact, if we ourselves try to disobey, or perhaps by action, by words, or by deeds, try to perhaps demean them or make it look like they do not have the power we ourselves, the Constitution has given them, we will be doing ourselves any good. So for that side, I'll plead. Such comments and such actions apparently trying to go against the Supreme Court's position, I think we can slow down on that, because we will not be doing ourselves good. Then comes to the majority-minority. And some view is that the side that is majority is determined by the number of seats that you win the general election. This is fundamental. I think that any means by which a political party wants to become a majority should be something not to be taken too much of a serious. For example, today, God forbid, but any side should not rejoice that maybe a member is sick or dies, let's say dies, expires. And so for the moment where, may his soul rest in peace, lawyer John Kuma of just died, for that period, we are the majority. Or for something. I mean, let us not wish that an event will happen in Parliament to make us majority. Let's primarily take the elections on head-on, win majority, the constituencies, and the majority. That would be my advice to the majority side. It is not so much to be excited about that a certain constitutional forgive me, so a gap in our constitution, we want to ride on that to become majority. That for me is a secondary issue. Primarily, my very good friend, admirer, Honorable Ayariga, and all the side, my friend, Honorable Atufosin, and all the members of Parliament, majority, minority, knows that it is the outcome of the contest of the various constituencies that decides majority or minority. And that should be where the emphasis is. That should be where their energies should be channeled towards, and not to pray that or ride on a certain gap of the Constitution to become a majority or minority thereon. So that would be my position. The controversy, majority, it's quite political. It's exciting. Like I said earlier, we can learn from it. But by way of object, they know how a side becomes majority. It is not through lapses in the Constitution or a certain whatever. It has to be by the counts at the various polling stations. And very soon, in the next maybe 4 weeks, will be confronted with a similar occasion. They should try and channel all their energy to secure majority there, and not to pray that along the line there will be some loopholes, a gap or whatever, to the extent that if a Supreme Court shares a position on it contrary to their view, it may appear as if they disagree with the Supreme Court to the extent that they may want to disobey or some. I'm not sure they are going to do that in principle, but
okay.
It shouldn't make it look like they will do something like that.
Professor Sapong, we are grateful, and some would say that indeed they are politicians. So if there are loopholes, like you said, definitely it must be exploited. But you disagreed extensively with some of the comments that Professor Sapong was making. Maybe
I just don't disagree, but I am dumbfounded because when you use the word professor, I thought that he was going to read 97 and say that because I'm from Boku and my English is not very good, my understanding of the English is flawed. I thought he would have read Article 97 and said, when it says that a member of parliament shall vacate his seat in parliament, I thought he would have said, no. Even though the language is very clear, you should go to High Court to go and get an order from the High Court. So what the Speaker did by communicating that, you see, this country, we need to be true and honest in our participation in the governance of the country. The old man, Uncle Sam Okudzato, who intervened earlier, after he spoke, I pointed to specific provisions of the Constitution and read them to listeners and gave them my understanding. I'm expecting one of them to also take the Constitution, read them, and then tell me that, what you are saying is not what the Constitution is saying.
But we have all agreed here that, of course, the Supreme Court also has jurisdiction on certain matters, and we've talked about it here. So for you to say that matters of law and Constitution has not been quoted by any of them does not mean that their submissions are invalid.
They haven't read any specific provision.
No?
Which provision? This professor who just spoke, did he mention any specific provision? No, he didn't mention any specific provision of the Constitution and why he's saying all the things that he's saying. No. So when you behave that way, you encourage wrongdoing in this country. Even if the Supreme Court misleads this country, you should have the courage to say, hey, you are misleading this country. Sam Okudzato is worried about chaos, political instability, citing the sub-region and say, the whole sub-region is in chaos, and Ghana is the only island.
And not rightly so. And not rightly so. That we have two sides all saying they are the majority. Should we not be concerned? We've seen what happened here on January 7 in that
Ghana
parliament.
is an island of peace because we have a constitution that guides our behavior. If we respect that constitution, we'll continue to enjoy that peace. If we undermine that constitution, is that okay? The basis on which
you can be also accused of undermining that same constitution.
The basis on which when you go to the polls and you are voted by the majority and then they count and they say, you Akufo-Addo, you have won. And then we all respect. And you even say, I should be prosecuted. And I go to court and be prosecuted. You say, you appoint this person to be collecting taxes, so you pay your taxes to him, and I pay my taxes. It's not your strength that you are using to compel me to pay taxes. You are using the authority given to you by the Constitution. I'm saying that when you begin to try to undermine the Constitution, based on which I have been subservient to you, people will react. So people like Sam Okudzato should be talking to the Supreme Court, not to us. They should be telling the Supreme Court, be cautious. Please, pay attention to the wording of the Constitution, because we all order our lives on the basis of what we perceive as the wording of the Constitution. Where it gives you power, exercise them. Where it says the powers are for the High Court, please allow the High Court to exercise it. Don't arrogate to yourself what is not yours.
Speaking of
and then
powers,
say that because, there's problem in the sub-region, we should all, just follow like zombies. No.
Speaking of powers and the options available and the channels available when it comes to concerns as this that has been raised, do we know if the Speaker or your side, anybody making moves to stay this particular directive from the Supreme Court and execution?
So I should come and discuss our strategies on Joy.
I'm only asking a question.
I'm
allowed to ask questions.
I should come and speak on Joy FM and discuss the strategies of our side,
questions.
Whether our side has... I won't tell you anything. All I'm telling you is that as we sit, we have not been served with anything. In fact, we are not party to anything. Because Afremaken didn't send we the majority to court.
The NDC side.
We the majority. We are the majority
the NDC
to
side.
court. We are the majority, the NDC side to court. He didn't send us to court. It's the Speaker and the Attorney General that he sent to court. Is that okay? The court didn't mention us in its directives, okay? The court mentions the Speaker. So I'm saying that we're all waiting for Tuesday. But what I know is that we, the NDC side, we will defend this constitution and our understanding of this constitution. And our understanding of this constitution is that one, the High Court has, the Supreme Court has no jurisdiction. Two, the Supreme Court has no authority to direct Parliament to suspend its decision. The Supreme Court has jurisdiction to determine whether a conduct violates the provision of the constitution. But we're saying that this is an instance that falls under Article 97, and Article 97 is governed by Article 99, and 99 says that anybody who has an issue with whether a seat has become vacant should go to the High Court, not the Supreme Court. Okay. We will defend all that, we will fight that, and as for Tuesday, what will happen, that one is a matter for
just a minute,
the Speaker to decide.
Mr. Ayariga, in that fight to defend the Constitution, which everybody will agree with, does it include the use of legal means?
Freedom of expression, as I'm sitting here, I'm fighting. Is it not legal?
Yes.
If it wasn't legal, will you be giving airtime frequencies and then you will call me? And this is the fight.
This is not a court. This is not police.
Why do you think the Constitution guarantees freedom of expression?
I understand.
Because the freedom to air your disagreement and your grievances, is that okay?
Yes.
Is so fundamental to the functioning of a democracy and the maintenance of order that the Constitution guarantees it as something that is inalienable.
That particular option more
so
than
we are
the
fighting,
other legal means.
We are fighting, we are resisting, we are rejecting, we are communicating our resistance and our rejection. Are you getting the situation?
Okay, so on Tuesday, which side are you sitting?
I've just told you that we are law-abiding.
Okay.
We believe that the judiciary has its province. The Constitution says that we, Parliament, should not interfere in the work of the judiciary.
That point you have made.
And then we're also saying that the Supreme Court also says that the judiciary shall not interfere with
all
our
that
work.
You have said. I'm asking about Tuesday. People are concerned.
On Tuesday,
the public perception and the issue about trust comes up. So I'm asking.
On Tuesday, we will go to Parliament. On Tuesday, when we get to Parliament, you will know what will happen.
Are you sitting on the right side of the Speaker or the left side of the Speaker, where you sit as we speak in that tent?
You will know on Tuesday.
Unfortunately, you're not going to the chamber. You're going to the tent.
You will know on Tuesday. It's the chamber. It's the chamber.
They are told some of you are actually going to sleep in Parliament, maybe at dawn and all that.
I'm saying that
part of the plan?
On Tuesday, you will get to know what will happen. But as we speak, we take a position that we are the majority in the Parliament, pending what the Speaker will tell us on Tuesday.
But we will not see chaos, will we? Can you guarantee us that?
Oh, well, you know, I don't know what you mean by chaos. What is chaos?
What we saw on January 7th, for instance.
What part of it was chaos? Was it the soldiers coming in? Was it the police coming in? What was the chaos? The chaos was soldiers coming into the Chamber of Parliament when they ought not to come into the Chamber of Parliament. The chaos was policemen coming when they ought not to come. If policemen don't come, what do you call it?
Come into
if the policemen, it's not their job. You see, that's the problem. The police. Don't forget that the police is the executive arm of government. The police belong to the executive arm of government.
You have marshals in there. They were
exactly. So we have our own marshals.
Overwhelmed.
And they didn't say
were overwhelmed.
They didn't say they called for reinforcement.
Okay.
They didn't say that we are overwhelmed and therefore we are calling for reinforcement.
We need to protect you as our MPs.
We haven't told you that we are threatened. We are threatened by the soldiers, not our marshals.
Oh, okay.
We are not threatened by our colleagues on the other side. We look, after we do all the things we do,
so we should not be worried.
Sit and drink our tea.
We should not be worried that what happened that day will be replicated on Tuesday.
I am saying
we can
that,
sleep and rest easy.
I am saying that, you see, we need to defend this constitution and we need to defend this democracy. Sometimes the enemies to the democracy will come from places that you will be surprised about. You see, when Uncle Sam spoke, and he is the one saying it, not me, he drew attention to judges that were murdered in the past. He drew attention. I didn't. I'm careful the kind of issues that I discuss on air. But he spoke about judges being murdered in the past. For which reason we have Martyrs' Day.
Yes.
Is that okay? Ask him, why were the judges murdered? Ask him why the judges were murdered. Ask him why the judges were murdered.
Let me take.
Who wants judges to be murdered again in this country?
Let me take comments that we've received. Some of your comments. Kofi Otabil says, I expect the Peace Council and eminent citizens should be working behind the scenes to initiate dialogue and put forward proposals to solve the impending impasse before it escalates. We have a beautiful country and calm heads must prevail. That's Kofi Otabil. Your message. Tahiru Dabre says they should respect the court decision, but then the court must not dictate to Parliament what to do. Parliament is an arm of government, likewise to court. The Speaker will settle this on Tuesday. Those who are making noise should relax. That's Tahiru Dabre's comment. Nali Tingo GH says if the court decision is allowed to hold or stand, one day someone will use the court to hold this country to ransom. I expect the Speaker of Parliament to ignore this decision. Being a CJ doesn't mean you are the epitome of interpreting the law correctly always. It is just an opportunity. This interference must stop. And this one is, and also Elliot has a very long one. I'll try and go through this. It says, let's be frank, Ghanaians elect leaders to improve their lives, not to engage in endless political power struggles. While parliamentary caucuses are necessary for healthy democracy, their real value lies in their ability to foster policies that generate economic prosperity, reduce inequality and improve living standards. And he goes on, unfortunately, since 1992, both majority and, okay, so it goes on. I have one from Kingsley Sapon. Let's go. As a country, we can only abide by the order of the final authority of the law, that is the Supreme Court. Kingsley Sapon said that. And also, okay, so that's some of your messages. And I'm told that Lawyer Kujetu stayed with us throughout this particular conversation. It's only fair that I give him one of the closing remarks before I come to Mr. Ayariga. So I'll give you 2 minutes. Thank you for staying on with us. Let's just wrap up with you on this, all that you've heard and all that has been said. Let's hear your final remarks on this. You would have to unmute, please.
Okay. I said it's a lot amazing. I see a young man, Yariga, trying to challenge my integrity, my understanding of Constitution. Sometimes we need a little bit of modesty in the way we argue matters. Let me just say that if a Supreme Court has urged, you go to the court to go and argue them to change their mind if it is possible. That is all that there is to it. He seems to be quoting the Constitution. I'm telling him that the Supreme Court, according to our Constitution, has an overall jurisdiction on all matters. And that when they were talking about human rights, who took the people to the matter to the Supreme Court, to the Supreme Court because of violation of human rights? Who did? Who said that? They are the one fabricating that. There was no such application, so far as I am aware, that the matter they took the Supreme Court was a violation of human rights. Constitutionally, it is only the Supreme Court that has the power to interpret the Constitution, not Parliament. Not Parliament, not the High Court. Indeed, the Constitution says that if a matter is pending before the High Court and there is an issue of constitutional interpretation, they must stop and refer the matter to the Supreme Court for the Supreme Court to run it. And I have spent 61 years in this law practice. And Mr. Yerga cannot claim that he knows more law than I do. I think he needs a little bit of modesty in the way he's making pronouncements. I don't go and attack lawyers to say that they're ignorant. I can say I disagree with you. but I don't go attacking them. So you should just learn to be careful and respect. Show respect. This nation, there must be respect for the elderly. Thank you.
We are grateful. That's Samuel Lokujeto. I think we are really, really out of time. Mr. Yariga, let's wrap up. I will have a minute to go on this briefly. Let's go.
Well, I mean, I have so much respect for Uncle Sam Okujeto, but when he's speaking as an MPP member, he should say so. That's my problem.
Okay.
But if you are speaking presumably as Council of State and a lawyer of 50 years standing at the bar, I expect to hear that.
Okay.
When I hear the MPP in you, I will point that out because I don't hear the law in you.
That's our show
problem.
for today.
I have a copy.
We really have to go. We are off. They are taking us off. We have to go. We really have to go. We have to go. Really. Thank you so much for joining us here. We are grateful to all our guests for today's edition. And of course, the discussion has not ended. We'll continue on that. I am MFA Paul. There's more when you log on to myjoyonline.com. This has been The Probe. Thank you so much for your company.